Hey everybody, Bill O'Leary jumping in here live. And I'm going to talk to you about a topic that I run across in my law practice. Maybe something a client has talked to me about, maybe I've read about and whatnot that I find interesting. This talk is part of our Thirsty Thursday series. So this is where I go live every Thursday, for the most part, talk about a different topic I run across at my firm Legacy Planning Law Group located in Jacksonville, Florida. So if you're thirsting for knowledge, information, guidance, that kind of thing, helpful tips, you've come to the right place, I'd like to think. So the topic today actually came up not too long ago from an existing client. How to handle out-of-state property in your estate. So you own property, let's say in Florida, but you also own, let's say that cabin in North Carolina, that piece of vacant land somewhere else in a different state. So out-of-state property can for sure present unique challenges to your estate planning, both challenges that are legal, obviously, but also logistical. So understanding how to manage these properties within sort of your estate plan as a whole, it's really important so as to prevent delays and avoid unnecessary costs for your heirs. So you see, one of the primary challenges of owning property in another state is that it's going to be subject to a separate probate process in that other state. We call that ancillary probate. So not only may your heirs have to go through the probate court mess here in Florida, where you, let's say, live and you pass away in Florida, but also they're going to have to go through a second probate process in that other state. Again, called ancillary probate, where that property is located. Because you see, the court here in Florida doesn't have any control over, any authority over, any jurisdiction over property in another state. You have to open up a second legal case in that other state. Okay? So the additional probate can be time consuming. On top of the time consuming nature of the Florida probate, add additional cost and legal fees. So if you think about it, with two probate cases going on at the same time, your heirs are going to face additional legal fees and delays in receiving their inheritance, what you want them to get. One of the most effective ways to manage out-of-state property in your estate plan is by setting up a revocable living trust and putting that out-of-state property into your trust. This is going to help avoid a probate, again, not only in Florida, but also in that other state, sort of the double probate problem, and can greatly simplify the process for transferring property after you die. Property held in a revocable trust, you see, bypasses the probate mess, which means that the property can be distributed according to your wishes without requiring that second ancillary probate. And yes, out-of-state property can be put into a Florida revocable trust, which again eliminates the need for two probates, one in Florida and one in that other state. And just so you know, when setting up a revocable trust, revocable living trust, while you're alive, you still maintain sole control over all of your affairs and all of your assets, which means you can, buy and sell assets, you can lease assets, you can access financial accounts and so forth in the exact same way that you could before. Now, another option to avoid ancillary probate in the other state is to add a joint owner to your out-of-state property title. This ownership arrangement is called joint tenancy with right of survivorship, and that then at your death, the property would automatically go to the surviving joint owner. Again, no probate. So this may be another way to facilitate a smooth transfer of ownership. I'm frankly not a big fan of sort of adding your, let's say, adult child onto your property title, because you then open yourself up to unnecessary liability risk. What do I mean? Think your adult child that you put on the deed or the title, then they get into that car accident and it's their fault, and here comes that injured driver. They can force a sale of the property and keep half of the proceeds from the sale. A revocable trust is a much better way to go about this in a way that you're not going to take on that additional liability risk. Now, that's just the word of caution I want you to be aware of. So if you went the joint ownership route, just be careful in who you select. But again, I'm not a fan. Remember, property ownership and estate laws, they're changing. They can change over time. Plus, what else can change? Your intentions, your desires on who you might want to receive your out-of-state property after you die. That can change over time. So the importance of regularly reviewing your estate plan is going to ensure that your out-of-state property and other assets are accounted for and align with your wishes as they may change from time to time. Changes in family dynamics, financial circumstances, or even property ownership can impact your plan, again, making the updating process very important. So managing out-of-state property in your estate plan at first blush could be seen as sort of a complicated, complex, but with the right strategies and the right help, you can simplify the process for your heirs. But the important thing, be proactive with your estate plan. Regularly review it, and that's going to ensure that your properties are protected and passed on according to your wishes. If you'd like to know a little bit more about, so let's say you have out-of-state property, how to handle it, how to pass it on to your heirs in the quickest, simplest way possible, and maybe you want to know, hey, how can we help you? We'd love to talk to you. So we invite you to schedule a free 15-minute phone call with our team. We call it our discovery call, where we sort of discover each other. You tell us what your issue is. We tell you if we can help you. Booking that call could not be any easier. So you can either go to our website, legacyplanninglawgroup.com, click on the book your free call button. Can't miss it on the homepage. Takes you to a booking calendar. Pick the day and time that works for you. Or if you happen to be watching this video on our YouTube channel, then appearing at the bottom of this video about now should be a box that pops up. It's a clickable box. Click on it. Takes you to the exact same booking calendar. Again, that call is complimentary. So, by the way, if you like this video, we would ask that you actually like it and share it with your friends. And again, speaking of that YouTube channel, do subscribe. We have more subscribers all the time, and we are very grateful for it. We're putting up more and more new and different content all the time. So I hope you've enjoyed this talk about how to handle out-of-state property as part of your estate. I'm going to give another talk next Thursday at about the same time, give or take. Again, part of our Thirsty Thursday series. So if you're thirsting for knowledge, we will quench your thirst. So Bill O'Leary, signing off for now. Go make it a great day and a better world. On behalf of everybody here, we call ourselves Team Legacy.